attorney for her office, and then representing the state is Assistant Prosecuting Attorney Adam King. Now, Ms. Barber, you and your client both stipulate to this matter being conducted by Zoom rather than an in-person appearance in the courtroom.
Yes, Your Honor.
And you're in agreement with that, Mr. Ames?
Yes, Your Honor.
All right. But since you're not in the courtroom with your attorney, if you at any time need to speak with her about anything or ask her any questions, just tell me, and I can put the two of you into a breakout room, which would be just the two of you on the screen talking with each other. No one else can hear you or see you. Okay?
Okay.
All right. Now, Mr. Ames is charged in looks like 9 count in. Well, there's a 9 count indictment involving 2 defendants. It looks like he's charged in counts 1 and 2, and then 6, 7, 8, and 9, with various aggravated trafficking and aggravated possession of methamphetamine. This is the actually the first final pretrial set on March the 3rd, and we have a trial date of April 25. Now, I received a plea agreement from Mr. Ames, which indicates that you are going to withdraw your not guilty plea and plead guilty to, looks like counts 6 and 8. And we'll hold this up to the camera and show you that that is the form that I'm looking at, and that's the form you saw the other day.
Yes, Your Honor.
All right, and on page 3, there are signature lines. About halfway down, there's a sentence that says, "I enter this plea voluntarily." Immediately below that, there's a signature line, which looks like Greg Ames 2/23/22. And I'll hold that up to the screen, and is that your signature?
Yes, Your Honor.
And that's the date you signed it, which would have been yesterday. All right, and you signed it there at the jail?
Yes.
And your attorney was there with you to go over and explain it to you?
Yes.
And did you understand that it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing hearing?
Yes, Your Honor.
Do you think you had enough time to fully consider this matter before making this decision?
Yes.
And are you entering into the agreement to plead guilty voluntarily?
Yes.
All right, now the agreement states on page 1 that you're going to plead guilty to counts 6 and 8. Count 6 is aggravated trafficking of methamphetamine under 2925.03A1 of the revised code, a 4th-degree felony. Count 8 is aggravated trafficking of methamphetamine in the vicinity of a school under the same section, a 3rd-degree felony. Now, it states that you understand that the maximum penalty for count 6 could be up to 18 months in prison if the prison term is imposed. Minimum would be 6 months, and a fine of $5,000. And then on count 8, there's a possible maximum term of up to 36 months. The minimum would be 9 months. There's different levels in between those two ranges. There's a fine of up to $10,000 available. There's a mandatory fine of $5,000, and both charges have possible license suspensions of 6 months to 5 years. You understand that?
Yes, Your Honor.
Now, under the law, if you are convicted of both of these offenses, the court could sentence you to prison and order those to be served consecutively with each other, meaning the maximum of 18 months on count 6 and 36 on count 8, or impose that would be 54 months. Do you understand that?
Yes, Your Honor.
Do you have any other felony charges pending against you in any other jurisdiction?
No.
And I know you're on community control for, I forget what it is it a 5th-degree felony you're on control for?
Yes. Yes, the aggravated possession.
All right. Well, under the law, if you are convicted of a new felony, that would be a violation of your community control in the other case. So this could result in a revocation of community control in that case in a prison sentence. And that's a 5th-degree felony, so that'd be 12 more months could be added on. So that'd be a total of, potentially, if you went to prison in all 3 of these, 66 months. You understand that?
Yes, Your Honor.
Okay. Now, other than the charge you're on community control for in this court, are you on community control, probation, parole, or post-release control for a felony from any jurisdiction?
No.
Now, under the law, under the law, if you are sentenced to prison and serve a prison term, once you complete that prison term, the adult parole authority under the sentencing law could, at their option, decide to put you under post-release control for a period of up to 2 years. They don't have to, they make the decision, the judge has nothing to do with it. Now, if they decide that you should be under the supervision, they'll set down certain terms, and you'll be supervised by a parole officer. And if during that period of time they determine that you have failed to comply, then they could return you to prison, even though you serve the entire prison term set by the court, for an additional period of up to 9 months for any one violation, but there's a half of whatever prison term was imposed by the judge for all violations. But if you commit a new felony while under post-release control, then in addition to whatever sentence the judge in that new felony case would impose upon you, that judge would have the authority to sentence you to an additional period, in this case, 1 year or whatever time is left on the post-release control term, whichever is greater. If that occurred, that would have to be served consecutively in the sentence in the new case. You understand that?
Yes, Your Honor.
Now, I'm not required to sentence you to community control for this offense or offenses. I can impose what's called, I'm not required to sentence you to prison. I can impose what's called community control or probation, like you are on now in another case. And if that occurs, you'll be supervised for a period of up to 5 years in a term set by the court. And if during that period of time the probation department feels that you're not complying, then they can file a written allegation of that with the court, serve a copy on you, and then you would have a hearing and be entitled to be represented by an attorney. And if you were found to have violated those conditions, then at that time the court could revoke community control and then sentence you to prison for the 54 months, applying you $15,000. You understand that?
Yes, Your Honor.
Now, the charge in count 6 alleges that on or about January 6, 2021 in this county, you did not only sell or offer sell methamphetamine Schedule 2 controlled substance in violation of Section 2925.03A1. Count 8 alleges that on or about January 12, 2021 in Hyman County, Ohio, you did knowingly sell or offer sell methamphetamine Schedule 2 controlled substance in the vicinity of the school. Both of those are violations of Section 2925.03A1, with count 6, as I said, being a 4th degree felony, count 8 being a 3rd degree felony. Now, Mr. Ames, do you understand what it is you've been charged with, what the state says you did, when, where, and how they let you did it in each of those 2 counts?
Yes, Your Honor.
And have you discussed those charges, the evidence in the case, possible legal issues in the case, the possible defenses you try to raise in trial, and the possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with her advice and confidence in this matter?
Yes, Your Honor.
Has anyone threatened you in any way to get you to plead guilty here today?
No.
And are you taking any types of prescription drugs that would influence your ability to understand what's going on or to relate your thoughts accurately?
No, Your Honor.
Now, on page 2, there are several lines that are printed, underlined. I'll hold that up to the camera, there toward the bottom. Now, I'm going to read that. It says, defendant shall enter a plea of guilty to counts 6 and 8. State will dismiss remaining counts. State will recommend community control of the STAR program. Defendant shall pay restitution in the amount of $120 jointly and severally with Steve Debo and $90 alone. And defendant will cooperate fully with the task force, including testimony if necessary. Is that your understanding of the agreement?
Yes, Your Honor.
Does anyone promise you anything other than that to get you to plead guilty here today?
No.
Now, under the law, Mr. Ames, the matter of sentencing is up to the judge, not to the parties. So even though there's an agreement that you should be sentenced to a term of community control with treatment rather than going to prison, that recommendation is not binding on the court. So if you decide to change your plea, plead guilty, once I've heard all the information submitted to me, if I think that's not the correct sentence, then I could decide to go ahead and sentence you to prison in this case for up to 54 months and revoke your community control in the other case and sentence you to an additional 12 months. You understand that?
Yes, Your Honor.
All right. Now, do you hold any license or certificate from any governmental agency of the state of Ohio that regulates any kind of occupation or profession?
No, Your Honor.
All right? You have certain constitutional rights you must understand before I can accept your plea. First of all, you have a right to have an attorney. Ms. Barker was appointed to represent you. Now, that wasn't simply to work the case out, but to provide any defense that might be available to you under the law that you wish to provide. So, if you decide that you do not want to do this, that you want to defend against these charges, then she will continue to represent you and defend you, including a trial if that's what you want. You understand that?
Yes, Your Honor.
Right now, under the law, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens from Highland County that reside in this county who are summoned for jury duty. Once those 12 are selected, the evidence will be presented, they'd be instructed on the law, and then that jury will have to decide by an unanimous verdict, meaning all 12 have to agree as to whether or not the state proved your guilt on either or both of the charges. Now, if you didn't want to have a jury trial, but you did not want to plead guilty, you can waive, which means give up the right to have a jury trial. In that case, you would have what's called a court or bench trial. And that means that it would be the judge would hear the evidence instead of the jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt by proof beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
Okay, now, under the Constitution and the law, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is the witnesses against you have to come into this courtroom in open court in front of you, your attorney, and a jury, and anyone else is present, and testify. And after that witness was done, each witness was done testifying, then your attorney would have the right to ask questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. You understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court to be able to testify on your behalf to same the state. So, if you have any witnesses which you're not certain are going to come in voluntarily, at your request, the court issues a court order that's called a subpoena, and that will force those witnesses to come to court and testify on your behalf if you wanted them to, even though they don't want to be here, which is the same way that the state's witnesses are required to come to court. You understand that?
Yes, Your Honor.
Now, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can make you testify. The prosecutor can't, the judge can't, you make that decision. And if you decide not to testify, the fact that you did not testify will not be used against you in any way by any person at any time. And no one can even comment about it except in one situation. That is, if there's a jury trial, you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
I was just pulling up the multitasking here, and I was reading the discovery, and actually Mr. Ames is on the intervention in lieu in the other case. And so what that means, Mr. Ames, is that you have not been convicted of that. You pled guilty, but you haven't been found guilty. But this conviction will result in a motion to terminate that will bring you back to court on that charge. You understand that?
Yes, Your Honor.
Okay. And if you plead guilty, you'll be found guilty, then I'll impose a sentence in that case. All right. Now, that doesn't affect your decision in any way, does it? You were aware of this already?
Yes, Your Honor.
Okay. I asked that question for you.
I did go over that with them.
Okay, that's what yeah. The way I answered it, you answered one yes and the other one no, and that was poorly worded. You did take this into consideration and were aware of it, right?
Yes, Your Honor.
And it does not have any effect, doesn't have any effect on your decision now. Do you want to think about it, or are you ready to continue to go forward?
I'm ready to continue.
Okay, all right, thank you. I'm sorry about that. I knew as soon as I said it that I said it wrong, so. All right, now. So under the Constitution, I'm going to go back and make sure I cover that. You have a privilege against self-incrimination, which means you can't be forced to give evidence in this matter at any time, including the trial. So no one can ever make you testify. The prosecutor can, the judge can. You make the decision. And if you decide not to testify, the fact that you did not testify will not be used against you in any way by any person. And no one's even allowed to talk about it except with one situation. If there's a jury trial, you don't testify. Then the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, Your Honor.
Now, under the Constitution, you're presumed innocent until proven guilty by proof beyond a reasonable doubt on all of the essential elements of each case, each charge. So what that means is that the burden of proof isn't upon you to prove you're not guilty. of these offenses just because you've been accused. The burden's on the proof to prove that you're guilty. The burden of proof is on the state to prove that you are. And so at trial, you don't have to present any evidence at all in your defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proving beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, ma'am.
All right, now, originally you entered a plea of not guilty. That plea denied the allegations in the indictment, denied you committed any crime, and it exercised or invoked all of the rights that I've just explained for you. Now, if you change your plea from not guilty to guilty, that plea is the opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. And that plea waives gives up all the rights that I've just described for you, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty would waive or give up the right to have a jury or court trial, would waive or give up the right to confront witnesses against you to cross-examine your attorney, would waive or give up the right to use the power of the court, power to force witnesses to come to court to testify for you, the same as the state uses it to have witnesses testify against you. Would waive or give up your privilege against self-incrimination because you're the one saying you're guilty, so that's what you define as guilty. Waive gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. Subjects you to being sentenced immediately by the court. And finally, waive gives up any right to file an appeal on any alleged violations of your rights you think may have occurred up to this point in the case. Now, if I should sentence you to the maximum sentence, or under certain circumstances you could file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. You understand all of that?
Yes, ma'am.
All right? And are you a U.S. citizen?
Yes.
And you're entering into this agreement voluntarily?
Yes, ma'am.
Now, do you have any questions about the two charges and the possible penalties?
No.
Do you understand them?
Yes.
Have any questions about the plea agreement?
No, ma'am.
You understand it?
Yes.
Have any questions about the constitutional rights I've explained?
No, ma'am.
You understand those?
Yes.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, ma'am.
You understand?
Yes.
All right. Is there anything you'd like to speak to your attorney about before we go any further?
Yes.
Okay, I'll go ahead and put you into a breakout room. Back on record.
Yeah.
All right, then you ready to go, forward, Mr. Ames?
Yes, sir.
Okay, do you have any questions about anything that we talked about here, this afternoon?
No, no.
All right, then is it your decision to, withdraw your not guilty plea, plead guilty to counts 6 and 8 according to the terms of the, plea agreement that we just gone over?
Yes, sir.
All right, then as to the charge in, count 6, which alleges that on or about June 6, 2021, in this county, you knowingly sold or offered to sell methamphetamine Schedule 2 controlled substance in violation of Section 2925.0381, a fifth degree felony carrying possible, fourth degree felony, carrying possible prison term between 6 and 18 months, and a fine of $5,000. How do you plead? How do you plead?
Guilty, Your Honor.
On count 8, which alleges that on about January 12, 2021, in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule 2 controlled substance in the vicinity of the school, in violation of Section 2925.0381 of the Higher Advice Code, a third-degree felony carrying a possible prison term of between 9 and 36 months, a fine of $10,000, and possible license suspension of 6 months to 5 years. How do you plead?
Guilty, Your Honor.
All right, the court finds on this day in open court, defendants abide by all the constitutional rights, made no intelligent voluntary waiver of the same pursuant to Criminal 11. Please accept in the order filed. Defense found guilty of counts 6 and 8 as set forth in the indictment. Then that would mean that counts 1, 2, 7, and 9 are dismissed as to the defendant. Now, Mr. Ames is currently under intervention in lieu of conviction, as I mentioned before, and I know that just took place last year, I believe. And there's not a request for an updated for a pre-sentence report. I don't think there's one necessary, but do each of the parties waive the right to have a pre-sentence report and agree to court rely upon the previous one and the information submitted today?
The state does, Your Honor.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Only what is contained in the plea agreement, Your Honor. One thing I do want to clean up. The plea form says the restitution amount alone is $90. It's actually $70 alone.
70? All right.
70 alone and 120 joint and several with Depot.
All right. Thank you. All right. Now, Ms. Gardner, anything you'd like to say on behalf of Mr. Ames?
Your Honor, I will say, I've had extensive conversations with Drake. I've been out to the jail multiple times to talk to him. I was out there last night. I really believe he's remorseful and that he wants to change and he wants to do the right things. He requested himself to go to STAR before I even got the offer of STAR. I spoke with Ms. Sturgill. She has a STAR bed date available of March 2nd. I think he's ready for a change and he's ready to move forward.
All right, Mr. Ames, anything you'd like to say?
No.
All right. Well, we'll have to deal with your termination of your ILC later, but for the time being, the court is going to accept the plea agreement, and it's ordered that you be placed on a term of 3 years of community control under the following conditions. You're to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times. You must report when and as directed. I'm not sure where all that was.
Explain cancer's Mike.
Who's Mike?
Selena cancer. Selena, mute your mic.
Yeah, you need to mute your mic there, ma'am. Hit mute. Yeah. Here, I just did it. I just muted you. All right. You must be truthful in all statements you make to the probation department or any employee regarding anything they talk to you about or ask you about with your community control supervision conditions. You must keep them informed of your residence and place of employment at all times, and at change either without prior permission. On leave the state will have any time without prior permission. You may not enter upon the grounds of any correctional facility nor may you communicate with or attempt to communicate with anyone who's an inmate in the facility without prior written permission. You may not, because of these offenses, purchase, possess, own, use, or have under your control any kind of a firearm, ammunition, or dangerous ordinance, and if you do, that would be a violation of both federal and state laws or felonies. It's also a violation of your free control, because you're not allowed to have those or any other weapon of any type while you're under your free control. You're not to purchase, possess, own, use, or have under your control any kind of a controlled substance, drug abuse, CBD oil, kratom, or any brand or analog of any of those substances that might have an effect similar to controlled substance drug abuse. Nor may you have anything that, any instrument, device, or thing that may be used to administer or prepare them for administration unless you have a prescription for any of those, and you must provide a copy of that within 24 hours of receipt. You're dismissed drug testing when and as requested. You're not to purchase, possess, use, or have under your control any kind of alcoholic beverage, nor may be present in places where the sold being consumed is otherwise lawful. You're not to associate with anyone who's a co-defendant in this case, or any other person who has a criminal record, member of a gang, or any other criminal group, or any other person who has in the past and could in the future influence you to commit a criminal offense or violate these conditions, unless that's approved in writing by your supervising officer. That would apply to any family members other than those with whom you were living with immediately before the commission of the offense. After the date of this order, you're not to permit to marry or establish cohabitation in a common law marriage type of relationship with another person without prior written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information so your ability to pay any fines, fees, or costs will be reviewed. You're referred by probation for any further evaluation, assessment, any other treatment or therapy or training or programming beyond that ordered by the court. You'll submit to that, and if there's a recommendation you complete programming, you're required to enroll in and successfully complete that. Pay the court costs of this action and make payment arrangements to do that with the clerk. You'll be required to do 400 hours community service for 20 hours per week for 20 consecutive weeks, unless you're employed at least 20 hours a week, a full-time student, or you have documentation from a physician or prior disability finding that you're physically unable to do that. It's ordered that you successfully complete the STAR program and recommended aftercare. And that is a requirement. It's 100%, Mr. Ames. It's not 95% of it, it's 100%. And if you don't complete it, then there's only one outcome for you, and that's prison. Because my position has always been, people can't complete STAR program, there's no sense in wasting any more time on it. And so, you need to keep that in mind. You must remain in the jail until complete STAR, which I understand will be March 2nd, and we'll prepare that order. Now, by being placed on community control rather than being sentenced to prison, you're deemed consented to a search without a warrant. Your person, residence, vehicle owned by you, or used by you, or any other property place is under your control, where you're found at any time, any officer of the probation department. Now, there'll be no fine, there'll be no driver's suspension. You are ordered to pay restitution in the amount of $120 running separately with your co-defendant, and $70 alone to the Hyden County Task Force to make those payments through your witness escrow account. Now, in the event that it's alleged that you have failed to comply with any of the conditions in this order, the probation department then will file a notice of that with, in writing, give you a copy. There'll be a hearing, and if the outcome of the hearing is that you fail to comply, then at that time, the court could revoke community control and sentence you between 9 months as a minimum and 54 months as the maximum, and fine you $15,000. If that happens, once you complete the sentence imposed by the court, the adult parole authority does have the option, if they choose to do it, to put you under post-release control supervision for a period of up to 2 years, meaning you'll be supervised by a parole officer the term they set, and if they determine that you have failed to comply, they can return you to prison, even though you serve the entire term set by the court for an additional period of up to 9 months for one violation, up to a maximum of half of your prison term for all violations. However, if you're validly on post-release control, then in addition, whatever sentence the judge in the new case imposed upon you, that judge is also authorized to sentence you, in this case, to an additional period of 1 year, whatever time left on that 2 years of post-release control, whichever is greater. If that occurs, that must be served exactly the sentence in the case. Also, you're ordered to pay the court costs. If you fail to do that, the clerk can collect that through various means if you're not making payments, including levying on bank accounts, wages, or any other assets you have. If that doesn't collect it, then before authority to do additional committee service beyond that already ordered, and give you credit for each hour worked, and I already accept by the board each hour worked, and reduce your judgment by that amount, so paid. All right. Ms. Parker, are you in Adams County on Mondays?
Yes, Your Honor.
What about Tuesdays as well?
I'm there Monday, Wednesday, Friday.
All right. Well, let's see if we can go ahead and set this ILC up. The state will need to file this motion, Mr. King, to revoke that, and we'll go ahead and get him in there and get that taken care of before he goes to start.
I'm available anytime on Tuesday, if
All
I
right.
can get it done.
Okay. Tuesday, we have any time in the morning? That's the first of the morning. Yeah, okay, that is grand jury day, so that'd be in the afternoon, I'm gonna take it. Well, the grand jury gonna be a fairly lengthy one, you think, Mr. King?
Yes, Your Honor.
What time are you gonna start? 9 o'clock?
Probably 9 o'clock, yes.
All right, let's do this at 8:30 then. So if you would get your motion filed before the end of the week, well, I guess that's tomorrow, and then we'll go ahead and deal with that, and finish up the conviction, and I'll put him on community control in that case as well then. All right. Okay, 8:30, very good. Not